All right. Well, as everyone is settling in, we'll go ahead and we'll get started with some introductions and dive into the heart of our presentation here today. Oop. First, we're going to figure out how to do slides. So hi, everyone. I am Jodi Daniels. I am CEO and privacy consultant here at Red Clover Advisors, and we are so excited to have you with us today to talk all about the Washington My Health, My Data Act. And I am joined by Mike, who I would love for you to introduce yourself to get us started.
Hey everyone, I'm Mike Hintze. I am partner at Hintze Law. We're Seattle-based privacy, data security, AI law firm. Seattle-based, but we have people all over the country. I also teach privacy law at the University of Washington Law School, and I'm a senior fellow with FPF. Prior to all that, I was chief privacy counsel at Microsoft. I was there for 18 years doing privacy and data security, compliance, and policy.
And Mike, we are so excited that you are here with us today. And to just kind of set the frame for, I really can do slides today, for today's discussion, we're going to do an overview of the Act, everything you ever wanted to know. And then we're really going to dive in deep about the substantive and consent requirements, talk about some practical compliance strategies, quite honestly, kind of throughout the section. And we will hold Q&A to the end. So please familiarize yourself with the little Q&A button at the bottom of the Zoom webinar. Put your questions in there, and then we will be sure to try and address them at the end. People always ask, will this webinar be recorded? The answer is yes, it will be recorded and then shared. To get us started, we wanted to do a little bit of a poll. We're going to have a couple polls throughout, and I'm going to launch this first one. So think about the priorities. So currently, how much of a priority is the Washington My Health, My Data Act in your compliance efforts? So your options are, it's a top priority, it's important, it's on par with all the other ones. Maybe you're just monitoring it, a little bit less of a priority, or this is a lower one, kind of an afterthought compared to all the other ones that you have going on. So I'm going to let some more people vote. We're almost there. Vote, 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 vote. All right, I'm going to end the poll and see where our results are. About half of you believe this is important and on par with the long list of other state and federal and potentially even global privacy laws that you might have. A third of you are monitoring it, feel like it's a little bit less of a priority. And then we have an equal number of you who have it is a top priority and it's a low priority. So this would be fun to potentially do the same poll, I think, at the end of our presentation. And after all that Mike shares, what you think about from going forward. Mike, do you have any thoughts about what we're seeing here with our audience today?
No, I think that's kind of what I would expect. I think if we were talking 6 months ago, we might have had a few more top priorities as people were kind of scrambling to get their head around this new law. And, it's been on the books for a number of months yet, under a year, but it's been in effect for several months. And I think this is kind of about what I would expect.
Awesome. All right, so let's get started. And Mike, I'm going to pass it over to you to help us understand a little bit more of the details on these laws. Or this law.
All right. Yeah, for sure. So the My Health, My Data Act was passed by the Washington State Legislature very quickly and overwhelmingly. It was largely driven by a response to the Dobbs decision overturning Roe v. Wade and threats to reproductive health care and abortion care, as well as gender affirming care. Those were sort of the key kind of talking points. It was also focused on addressing the gap where HIPAA covers the protection of privacy of healthcare data, but only for covered entities and business associates operating on behalf of covered entities. And there's a whole lot of healthcare data that falls outside the scope of HIPAA. So this bill was proposed and pitched and promoted as addressing those two important policy objectives. But the way it was drafted is problematic in some ways, particularly in regard to its breadth. It is very, very broad with respect to the kinds of data that it potentially covers. It's very, very broad with respect to the entities it covers, and it's very, very broad with respect to the consumers that it covers. And it has very, very strong substantive obligations. And some of the drafting is, frankly, not great and fairly vague. And so the combination of its breadth and its very challenging obligations has raised a lot of concerns, and it goes much further than addressing those more focused policy objectives that were articulated, but in fact has a very, very broad and very challenging in many ways impact. Add to that the fact that there is a private right of action in addition to Attorney General enforcement. It got a lot of people's attention, and it got a lot of people very, very concerned about the impact and the cost and the risk that would be associated with that. And we'll dive into those issues in more detail. And you can jump forward to the next slide. And I do want to come back to that enforcement piece, because although when we go through the law in the next several slides, you all who maybe aren't so familiar with it might start to freak out a little bit, combined with that idea of the private right of action, which can create a lot of risk and uncertainty. But there is some elements of enforcement that I think can give a little bit of comfort and can lead to reasonable risk-based compliance strategies. And then we'll talk more about that. But first, let's talk a little bit about the scope. So there's a broad range of entities that could potentially be covered by this, and you don't have to be based or even, physically located in Washington, or even particularly targeting the Washington market to potentially be covered by this. It applies to any entity that conducts business in Washington or that produces or provides products or services targeted to Washington consumers. And if you look at the Attorney General's FAQs, and I encourage you to do that, they've published a set of FAQs. We'll talk more about that. They're not spectacularly helpful, but they have a few little tidbits of insight here. That part about targeting services to Washington's consumers, the way the FAQs are drafted, it appears that the Attorney General is taking the position that really it just means if your products or service are available to Washington consumers. So any website, any app, unless you're actually geo-blocking Washington, is likely enough to bring you within scope of the law. And it's not just the ones that are offering and making available those services, it's those who are producing it. So it could cover manufacturers, OEMs, et cetera. It does apply directly. It has the concept of controllers and processors like many other privacy laws. It applies to controllers. It doesn't actually use the term controller, but it basically uses the terms that are from the GDPR definition of controller. So the entity that essentially determines the purpose and means of processing data. It only indirectly applies to processors. There's some contractual obligations that need to be pushed down to processors. It covers nonprofits, doesn't have to be a for-profit company. And some of the provisions apply to all persons, including individuals. So some of the provisions actually apply to individuals who may be collecting data, not just legal entities or businesses. It does exclude data covered by certain privacy laws, the most notable being HIPAA, the Gramm-Leach-Bliley Act, and FERPA, as well as some state-level laws that are focused on healthcare and insurance. But that is a data exclusion, not an entity exclusion. So it's very possible that some entities may be covered by these laws, but may be processing other data that would be covered by My Health, My Data.
Mike, one of the questions I often get is about the size of the entity. And so here we've talked about it, you have to conduct business in Washington, that commercial and nonprofit is included. Can you talk a little bit about what happens if I'm a small business?
Nothing. Everything applies to small businesses. The only difference, there is a definition of small businesses. The only definition is that there was a later effective date for small businesses, and that date is passed. So as of today, there is no difference between small businesses and the largest global corporations in terms of the obligations under this law.
And that's a really important piece because it's one of the few in the US that actually does that. It means everyone's included as opposed to so many others that have floors and thresholds.
Yeah. Yeah, next slide. So this slide is a bit of an eye chart. I don't expect you to read all of it, but I wanted to throw it up so that people could just take a look at what it looks like as we talk through it. So the definition of consumer health data, this law applies to consumer health data. And it's in that part A of the definition, it has a general definition. It's personal information that's linked or reasonably linkable to a consumer that identifies a consumer's past, present, or future physical or mental health status. And you read that and you think, okay, well, I've got a sense of what that means. It's my healthcare conditions, it's my status, it's the ailments that I'm suffering from, it's the treatments I'm getting, that kind of stuff. But no, you go to B and it says, for purposes of the definition, physical or mental health care status includes, but is not limited to, and then there's a long laundry list of things that are automatically considered part of consumer's physical or mental health status. And some of these are incredibly broad, and then some of them are incredibly vague. So I've highlighted some that can be potentially quite broad. Social intervention. What is that? That could be almost any conversation you have about a health-related topic. Bodily functions. Gosh, that's an awful lot of things. I'm moving my arm, that's a bodily function. When I eat, I'm digesting, that's a bodily function. So anything having to do with, anything having to do with the body really could potentially be covered by this. Biometric data, okay, that's not particularly surprising, but then if you go to the definition of biometric, which is over on the right-hand side of the slide, it is very broad. It includes behavioral characteristics. It includes imagery of the face, from which an identifier template can be extracted. Not that is extracted, not that is extracted and is used to identify. It's any imagery from which an identifier template can be extracted. So you're looking at two biometrics on the screen right now. Any sufficiently clear image of a human face would meet this definition. So again, potentially very, very broad impact. And then I'm just going to go to subpart 11 here, or sorry, subpart 12. The 11 is pretty broad too when it talks about precise location information, but I'm going to go to 12. It says data that identifies a consumer seeking healthcare services. And then if you go to the definition of healthcare services, which is a defined term, it means any service provided to a person to assess, measure, improve, or learn about a person's health. So a gym is a healthcare service. A bookstore that sells books on weight management is a healthcare service. A meditation app could be a healthcare service. A search engine that's used to help you learn about your health can be a healthcare service. Any website that provides information related to fitness or nutrition or wellness could be considered a healthcare service. So data that identifies a consumer seeking a healthcare service could just be your clickstream information, your search queries, purchases, a wide range of information could potentially reveal that you are seeking this broad range of services that could be related in some way to your health. So, you go, and there's several other parts here. There's a section in there about inferences and other elements of this definition that could potentially be interpreted very broadly. So when you think about this, it's in some ways it's harder to think. It's thinking about data that might not be covered by this is sometimes even a little bit challenging, because you can, spin a story about how lots of things could reveal things about people's health or intention to seek a service related to health. The advocates of this bill were talking about the the big story from 10 years ago when a young woman made several purchases at Target, all of which were quite innocuous, but their algorithm inferred a likelihood that she was pregnant and showed her ads based on that. And they kept talking about that. So if any of those kinds of purchases are potentially revealing of healthcare or somebody seeking healthcare services, it's hard to imagine what's not. So incredibly broad and room for a lot of creativity. And again, private right of action, plaintiffs' lawyers are nothing if not creative. We jump to the next slide. And then very broad data that's covered, broad scope of individuals that are covered. This is not just Washington residents. A consumer is a natural person who is either a Washington resident or whose consumer health data is collected in Washington. Okay, that makes a lot of sense given the intent of this, as somebody's traveling to Washington to obtain a healthcare service and their data is collected in Washington, you would expect that to be covered. But you look at the definition of collected, and collected includes the term otherwise process. And process is any operation or set of operations performed on consumer health data. So if data about you in some way touches Washington state, you would meet the definition of consumer here, including storage in a cloud service provider. And where are two of the largest cloud service providers on the planet headquartered? Washington state, with large data center footprints in Washington state. So somebody who's obtaining, a resident of Florida who goes to New York to obtain a healthcare service, and that data is stored in a cloud, in Washington state, that is a consumer protected by this act under these definitions. I will note that there is a important employee and B2B exception, because a consumer is defined as a person who acts only in individual or household context and excludes individuals acting in an employment context. So HR data, employee data, out of scope, B2B data, I would say pretty clearly out of scope as well.
Mike, I wanted to go back to the process part, because I know this is also a question many have. If I have, a server that is hosted by a large company based in Washington, is there a difference that anywhere in the company I have that, or it's the consumer health data that might be really broad that we just defined, might be stored on one of those servers that might be hosted in Washington state?
Yeah, if it's merely stored on a server in Washington state under this definition, that would be enough to bring it in scope, at least arguably. This definition of process is very similar to the GDPR definition of process in Europe that has been interpreted to include mere storage. So transmission into Washington state data center, storage in a Washington state data center. Clearly, if some operation happens on the data, it is processed, but arguably mere storage would be enough. Now, these large Washington-based cloud service providers do have data centers elsewhere, and some of them offer geolocation choices, and that's been done largely for Europe in the past, where you could choose to have your data stored in a European data center. Are any of them offering an option to keep your data out of Washington yet? I haven't seen it, but it honestly wouldn't surprise me.
That's a really excellent point. And now we'll talk a little bit about knowing where your data is. Oh, in just a moment, right here. Before we do that, we're going to do another poll. So thank you to all of you who have joined since our last poll. Just a quick friendly reminder, this is being recorded. It's always a common question. And we ask that you put your questions in the Q&A section below. We have a few polls to help make it fun and interesting here. So this one is, has your level of focus or prioritization on this law changed over the last 6 months? It has increased a lot because it wasn't really on our radar. It's increased a little bit since the law is now in effect. It's pretty much the same, or it's decreased. Where are you on your journey? I always think this would be so fun. We should do like a pre and a post based on all the knowledge that we learn in these conversations. All right. So thank you for those of you who have participated. We have about half of you have increased now that the law is in effect. just a little bit under, about 40% has stayed the same, and 8% of you have increased a lot. Actually excited that 0% have decreased now. So good job. Appreciate you participating again in that poll. Well, we've just talked about what constitutes the type of consumer health data that might trigger application for this law, which the next important question is trying to figure out, do you have any of this? And we love a good data inventory here at Red Clover, and we find this is really the starting point. You really do need to understand what type of data you have in your organization. What are you collecting down to that nitty gritty clickstream data that Mike, you just pointed out? How are you using it? Where is it stored? Because that storage piece is critical. We just learned that if it's potentially stored in Washington State, that might trigger processing. And then what you collect and identify today in a data inventory might not be what happens tomorrow. And what we find is a lot of companies will have a data inventory. It's not always updated. And creating what that process is going to be able to go back and make sure you've captured what the new product team has identified or what the new marketing team is asking on their list of questions in their cool quiz that they have on the website is really important so that you're constantly understanding the flow of data in the organization. That life cycle of data is very, very important. And there are some differences in the definition, as Mike shared. The really big detailed page needs to be part of how you're conducting the data inventory. It's going to differ from personal information in some of the other laws. The definition of sensitive is going to be a little bit different. Here, you're going to need to get very, very specific in your data inventory. Whether you conduct this in Excel or use a privacy software, it's going to be critical to break it down by business process to really understand how you're using it, the systems, and again, of course, that really granular data level. Mike, do you have anything else you'd like to add about the importance or how you've seen data inventories been conducted or how they've been used?
Yeah, I mean, I think it's absolutely critical. And obviously, this is not the only law that warrants doing a data inventory. There's lots of needs to know what data you've got and to categorize it appropriately, particularly when you're talking about sensitive data types. I think when it comes to this law, as we talked about, that potential, that definition of consumer health data is incredibly broad, potentially. There's a lot of gray in there. And there are some things that are clearly going to be covered. The things that we've always thought about as healthcare data. And there's going to be things in there that are particularly sensitive, things like reproductive health, which was a core driving motivation for this law. But there's some gray there too. And I think, different companies may take different risk-based approaches, even at this initial stage of data categorization. What are you going to consider consumer health data for your company that may warrant different treatment according to the different requirements that we'll talk about in a few minutes? And I think there are some reasonable risk-based decisions that can be made there. So, you need to talk with your lawyers, you need to talk with your data folks and think about how you are going to categorize it. How does it make sense for your company to take a very conservative approach or accept a little bit of risk in how you're defining these things? Are you really going to treat everything having to do with consumption of food as consumer health data? Are you really going to treat somebody searching for recipes because some of them might be considered heart healthy recipes? Is that going to be consumer health data? You could argue it either way. There's different risks involved with different decisions, but I think each company needs to make that decision for themselves.
Absolutely. And in that spirit of risk, one of the other pieces that often associates or is connected after we've conducted a data inventory are those privacy impact assessments. And this is where you can really take that a little bit deeper. So if you think about that recipe example, okay, well, what am I actually collecting? And how did I know that you are heart healthy, or does it just happen to be a heart healthy recipe? Do I collect and associate Jodi looked at the heart healthy recipe and then I'm going to use that for some other purpose? Individually, the data points need to be evaluated to figure out that element of gray and what else is going to happen. We also do have other laws that are important to kind of overlay on top of this. As many of you, and what I always hear is, gosh, there's so many different laws. They're so complex. They're starting to overlap. And I want to try and create a program that's going to really work for them all. It's important to find where the nuances are and be able to apply them. So some of your other laws are going to have these needs for privacy impact assessments. And here might be a great place from a data inventory perspective to make sure you've added on and captured the other types of data. Then we can look at the kind of processing. Maybe we need extra questions in our PIAs to be, or what might trigger us conducting one of those to be able to flag, oh, wait, this might be a processing that might trigger this law. And then we're going to think about, well, what are all the other obligations? We're going to talk about privacy notice in just a moment and what special obligations you have to have here. There are privacy rights that are a part of this law, just like many others. And what will your process and policy be? Mike, one of the things you talked about was really having that process and ongoing piece for data inventory. You know what, having and kind of like, what is your definition of what consumer health data will be? For me, I think having that codified is important. In other words, what is your company stance? And be able to know as you evaluate, this is our company stance. So you have to be able to create what that policy and position is going to be, and then evaluate everything that you're doing against that and continue to improve and adjust. Because what you decide today, maybe you're doing something a little bit different. Maybe there's an enforcement that comes out. Maybe there's an interpretation that comes out in a couple months. You might want to review and say, well, we took this position then. With this new information, I think we might want to adjust our position. And as a result, if you make that adjustment, you're going to want to go backwards and be able to see, oh, based on that adjustment, this is going to change up or down. It's either more in scope or maybe it's a little bit out of scope. So these assessments and the data inventory are, in my mind, just so critical to the actual bringing to life of what these laws are all about. Mike, what else would you offer?
I agree. And again, of course, privacy impact assessments, DPIAs, all of those kinds of documentation and risk assessment exercises are not unique to this law. And so, hopefully you have those processes in place and you've got an existing form. And that's one of the things that you can leverage for compliance with this law. Everything you have to do for this law is not net new. You can leverage things that you're doing for other laws as well.
Absolutely.
So let's jump into the substantive requirements. And this is just kind of an overview slide, and we'll get into more detail on most of these. So there is a consent requirement, opt-in consent for any collection or use of consumer health data beyond what's necessary to provide a consumer requested service. There's an even higher bar above GDPR level opt-in consent called authorization. And that would cover anything that's constitutes a sale of consumer health data, which sale is the same definition of sale under the California CCPA. And that's been interpreted to include most third-party advertising activity. So potentially using this very broad definition of consumer health data, any targeted advertising, cross-context targeted advertising involving that data could potentially be interpreted to be a sale, which would trigger this very high authorization requirement. There's a notice requirement, and it's not just adding a few more words to your existing privacy statement or privacy policy. This requires a separate consumer health data privacy policy that needs to be linked from every page on your website and in other locations. There is a broad access right, a broad deletion right. The access right is similar to what we see in other laws, but it includes a requirement to list all the third parties and affiliates with which consumer health data has been shared or sold. And the deletion right does not have the typical exceptions that we see in virtually every other privacy law. It doesn't even have an exception where retention of the data is required by law, setting up a potential conflict of law situation. There's a prohibition on certain uses of geofencing, And then there's data security requirements. We won't really talk more about the data security requirements because it's sort of that, reasonable measures language that we see in a lot of other laws. Let's jump in to some of the consent pieces. So as I mentioned, the opt-in consent for collecting, and remember the definition of collect includes process, or share consumer health data unless it's necessary to provide a consumer requested product or service, or it's for one of a list of security related exempted purposes. So there is a security exception in this law that would it basically says that nothing in this law prevents using consumer health data for the following, and it lists anti-fraud, et cetera. Protecting the security of systems. It's actually relatively broad in terms of security exemptions. So that's an important thing to keep in mind. It does not prevent you from using data to protect the security of your services, the integrity of your services, detecting fraud, et cetera. But let's focus on that necessary to provide a consumer requested product or service. If it's necessary to provide the consumer requested product or service, opt-in consent is not required. Big ambiguity there in my mind about whether or not that will be interpreted as being reasonably necessary or strictly necessary. And there's an important difference, and we actually see those terms in other state privacy laws, but this just says necessary, leading to the question of how that will be interpreted by the courts down the road. If it's reasonably necessary, I would say, there's a whole host of kind of back-end operations and auditing and analytics and stuff you could argue is necessary to provide the consumer requested product or service. But if it's strictly necessary, that presents a much more challenging scenario. I found that most companies are leaning into a little bit of risk here and interpreting that to be reasonably necessary. There's also some ambiguity about how do you define what is the consumer requested product or service. If you are providing a service and you want to use data to personalize that service, is that part of the consumer requested product or service? Is that personalization necessary? Well, I guess it depends on how you've really defined the service. What kind of expectations have you created? If you've created the expectation that the nature of this service is that it's highly personalized, I would argue that the use of data for personalization is necessary to provide the consumer requested product or service. If you've set a clear expectation that this is a service that evolves and improves over time, maybe you could make an argument that using the data for product improvement is necessary to provide the consumer requested product or service because that's how you have defined the scope of the service. So there's wiggle room there as well. And so there's a lot of interesting risk-based conversations you can have around what would actually trigger this opt-in consent requirement. There's another element of opt-in consent here that says you need to get opt-in consent to do anything beyond what you've disclosed in the consumer health data privacy policy. Well, the trick there is just draft that broadly enough up front so that you're not going to fall into that trap. So you're not seeking opt-in consent every time you want to do something new because it wasn't previously contemplated in the health data privacy policy. That's probably not going to be as big of a deal if you kind of future-proof the way you draft that. Jodi, is there anything you wanted to chat about that consent piece before we jump over to authorization?
I think we can jump over to authorization.
Let's do it. So as I mentioned, if anything you're doing with consumer health data constitutes a sale, and again, CCPA definition of sale, exchange of data for monetary or other valuable consideration, you need to get an authorization. And this authorization is not just opt-in consent. This is a signed document that has to list the consumer health data that's being sold, identify the purchaser or purchasers, describe the purposes of the health data, describe how the data is being gathered, specifies the name and the contact information of every seller and the purchaser of the seller and every purchaser. There's a bunch of specified boilerplate disclosures that you need to have in there. It's revocable at any time by the consumer, and it's only valid for 1 year. You would need to get a new authorization after 1 year. So you can imagine how specific and long and challenging it would be to actually seek and obtain this kind of authorization. And if sale is interpreted broadly enough, such that it would include, as it does under the CCPA, most cross-context third-party targeted advertising, this kind of authorization just isn't scalable in that kind of context. So operationally, that would be nearly impossible to do. So, some people are looking at this and saying it's effectively a ban on the use of this broad scope of consumer health data, depending on how broad you're interpreting it, for online targeted advertising. So one of the things that people are doing is looking at their targeted advertising, and I know we're going to talk about cookies in a minute, and saying, well, are there segments that we have that are touching on health topics? Maybe we just eliminate those. Maybe we're more conservative about health-related topics to at least take out some of the obvious cases where it might be deemed a sale of consumer health data. So looking closely at targeted advertising and your advertising ecosystem is going to be really important here.
So we were talking, you were talking a little bit about, I'm not sure why privacy rights and process got up here, but we're going to talk about it anyways. So if we were to think about what we just described, where I have, all these different rights, the idea of being able to be deleted, and then we were thinking about, well, do I even have the opportunity as an exemption? And I have to line those up across all of the other privacy laws that I need to be thinking about, or my own retention practices. Having a process and a policy at the beginning is going to be incredibly valuable to help you think through, what do you do when Susie makes this request? First, you really need to understand what was your definition of consumer health data. So the data inventory that we talked about is critical always. We're going to need it to figure out, did we sell any of that data? Do we need consent in any places? And then we're going to need it here for privacy rights. We're going to want to think about, if you have an existing privacy rights process, we talked about, more than half of you are already thinking about how does this, it's on par with the other state and federal and maybe even global privacy laws that you have. So how will you factor this in to your existing program? What tweaks do you need to make? Do you have a manual process? Do you have an automated process? Are you using software for the web form, but maybe manual behind? You'll want to think about, really, what is that process? Who are the people? What is the data? Who are the steps? Where is that data? Can I delete it? Can I not? And then make sure that you've made any of the tweaks, whether that be a manual process or in software. And one of the critical elements is training, because whoever is responsible for managing all the different steps, maybe it's one person, maybe it's three, maybe it's a long list of them. Everyone needs to be aware of what will happen, and people's roles change. You'll want to make sure that you're training and documenting what are those steps, so that when someone either changes roles, maybe they even go on vacation, that you're able to manage the process overall without really missing a beat. We don't want these to be sitting in a long queue and they get ignored. So I would also say, don't create a process, implement software, and then ignore them. The software doesn't do the work in many scenarios. There still is oftentimes a human involved, and I've seen that. They get it all set up and then they don't do anything. So the other important piece, though, you're going to get it all set up, just like with the data inventory. You need to maintain a schedule to be able to capture changes, because perhaps there's some brand new marketing product, new feature, new website, new page, new something, new vendors, and you'll want to make sure that that is reviewed and incorporated into this entire process and policy as well.
Yeah, and I would just add, again, I think I've said this on multiple occasions now. A lot of this is not unique to My Health, My Data. The data access rights, data deletion rights occur in many, many privacy laws. So this is a process that you need to have in place anyway. And I'm a big fan of, not doing extra work, leveraging what you've got. Keep it as simple as you can, because complexity leads to error, and error leads to legal risk. And so think about, what do you need to do that's different for this law with respect to consumer health data? Well, if you're providing access to all personal data effectively, well, that's not different for consumer health data. What is different under this law is that access right includes a right to get a list of third parties and affiliates with which you have shared or sold the personal information. So if that kind of information isn't available to you in your existing data subject rights process, that's something new that needs to be built in. How can that information be tracked? How can you compile and generate that list and provide it to consumers in response to access requests that are made under this law? And do you address only the consumer health data in that context? Or for the sake of simplicity, do you just apply that to sharing of any personal data that you might be sharing with third parties? Again, those are questions you need to ask yourself. Do you err on the side of just simplicity by treating consumer health data or treating other personal data as you would treat consumer health data? Or do you want to slice and dice it more finely and maybe add additional complexity, but maybe save on, the amount of systems that you need to query to respond to these things? So again, that question may be different for different companies, but I think working through those questions and then building that into this policy and keeping it up to date, as Jodi mentioned, is going to be really important.
Thank you, Mike.
So let's talk about notice. We talked about that the law requires a separate consumer health data privacy policy. When the law was first passed, the language of the statute suggests that it's a separate document, but I was having some conversations with clients about, well, can we make it a section of our main policy? Can we just add in a few other things in our main policy, even if it's not its own section? And I was, thinking, well, each of those involve a little bit more risk because they seem to diverge from the implication of the statutory language. But there's nothing in the language doesn't actually say it needs to be a separate privacy policy. Well, the Attorney General's FAQs came out and said, yeah, it has to be a separate policy and it has to be separately linked from the homepage, and it has to contain only what's required for this consumer health data privacy policy under the law and nothing else. So that sort of put to rest this question of whether or not you can get away with not having a separate consumer health data privacy policy. And I'm sure many of you have seen, Washington health privacy policy links spring up in footers around the web. They're on many, many websites now. And that's the reason this law requires that you have yet another separate privacy link in your footer. Those footers are getting awfully crowded with privacy links, which, from a policy standpoint, I think is terrible for consumers because nobody knows which one they need to click on, or if they need to click on all of them, and all of them are, 75% redundant of each other. So, it's not a great consumer experience. So that's what the law says. I'll also flag that the law says it has to be linked from the home page, but the way homepage is defined, it effectively means every page of a website, because it says a homepage is the landing page or any page on which personal information is collected, and not just consumer health data, any personal information. And the definition of personal information includes IP address. And because that's kind of how the internet works, every website, every web page collects an IP address. That means that you have to have the link on every web page.
One of the things I want to remind everyone here is the importance of working with whomever owns the site, because as new pages get added, you'll want to make sure that if you have this requirement, that privacy policy link goes as well. So some companies have a standard footer that includes all these links, and some don't. Some are every page, basically, that footer is recreated, and it's very much just dependent on your website architecture. And what you want to ensure is when a new page gets added, there's a long list of a checklist, essentially, that those teams are thinking about, you'll want to make sure this is on that too, because we wouldn't want a brand new page getting created and oops, this little link didn't make it over there. So something to be mindful of, identify who are the teams in your organization who own these website footers and making sure that you're getting that link updated.
Good point.
So a little bit on cookies. This is, another extension, if you will, of the data inventory piece. And we are also talking about targeted advertising. When we think about a cookie program, think about pixels and digital trackers. We're still kind of in the cookie era, but there are other pixels and other trackers and they're alternate IDs. They're really, really similar. The important piece is to have the plan in place to be able to review them. Because if you're going to be one of those where you want to exclude those segments and those potential trackers, you're going to need to know what you actually have in place. And again, this theme of when you do it now, how are you going to maintain it? Because teams are adding these all the time. You're going to make sure that you have flagged and identified, oh, wait, I don't want this page or that type of information or excluded in this particular capacity. If you have a cookie piece, some type of a cookie banner, cookie opt-out, you're going to want to make sure that you review that. So if you have a cookie consent solution, review the setup and make sure what you have either globally for the states and then what you need to have for Washington is set up appropriately. Perform regular audits. We do these all the time, and we often find that what it was set up on day one is not actually what's happening some future date later. Websites change, things break, new pieces are added, and then expansion happens and someone just kind of forgot to go back and review that. What are your cookie standards or tracking standards? How do you even get one of these in the first place? So think of almost a pixel governance or a cookie governance program. Are you okay with anyone adding it to the site? Should there be a lockdown? Do you want to review who these vendors are? So think about all of the elements of a tracker in a pixel. Who are they? What are they collecting? What are your rules? What's important for you? And create that standard that the company needs to adhere to. So your own internal cookie policy, if you will. Making sure you have a QA process. So anytime, I just mentioned the new site, make sure you have your appropriate privacy links. We're going to also want to make sure that we have the right consent or blocking, whichever one's going to be appropriate. So create some type of QA process that's actually going to review the entire consent or opt-out scenario or the blocking scenario that you might have. And overall, if you're going to choose to have a banner, you want to make sure that it's actually updated. And what are some of those details that you might have, excuse me, in a regular cookie audit? If you have a cookie banner, you want to make sure that you have the right language that applies to the jurisdictions that you're in, that adheres to the kind of data that's actually being collected, the kind of trackers that are here. So understanding which ones you have and what they are doing are essential. And then you want to make sure that if you have a banner, you have the right settings actually set up in the software tool and truly testing it. Is it actually working? Oftentimes it might the first couple times and then something happens. What about categorization? Not everything is going to be strictly necessary, even though you might think it might be strictly necessary to your organization. You're going to want to review and make sure you actually have them appropriately categorized. Thinking about your external cookie policy, but truly think about your internal cookie policy. There's a lot of conversation on dark patterns, really making sure, do you have the right colors? Have you tried to skew someone to a particular decision? Really making so many different laws these days have dark patterns. And I think even if someone doesn't say dark pattern, they're going to care about dark patterns. And then universal consent signals and how is your software listening to them? Mike, I would love to turn it to you to share your thoughts on the universe of cookies and pixels and banners.
Yeah, I think it's really important for all the reasons you stated, but I'll emphasize a couple. One, just doing the inventory, knowing what third parties are present on the website is going to be really important because of that access right. That access right to say for consumers to say, hey, tell me what third parties' data has been shared with. If you've got a person running your website who's just randomly dropping new pixels on there all the time and not tying that in with your data subject access processes, your list will be incomplete and you'll be at risk. And this is easily discoverable. You know, third parties out there can track which pixels are there and you know, do an access request. And I'm sure there are, you know, an intern at a plaintiff's law firm that will be doing something like that to test, to say, is the access list, the list I'm getting in response to an access request, align with what I'm seeing actually happening on the website. The other thing is the default settings for your cookie banner and your cookie consent management process. You know, a lot of companies have advertising and analytics cookies on by default in the US and off by default in Europe. You may want to turn them on by default in Washington. That's not necessarily a perfect compliance strategy because you know, a cookie banner that is off by default that somebody has to turn on advertising cookies wouldn't meet that stricter authorization requirement that we talked about, but it would be opt-in consent. And depending on how, you know, the courts interpret, you know, what's a sale and all of that, it could be a risk mitigator, and you might have at least a compliance argument there. The other thing, and you know, we talked a little bit about enforcement, and I want to jump into that here. And maybe this isn't the best place, but I think it's really relevant here when we're talking about risk-based approaches, like how you might set up in your defaults on your cookie banner for Washington State. There are two enforcers here: the Washington Attorney General and the plaintiff's bar. The Washington Attorney General is going to be motivated by certain policy objectives. They're going to be looking for truly bad actors, et cetera. And if you've got a cookie banner that's getting opt-in consent, somebody has to go and turn it on, and your cookie banner is sufficiently robust and it links to the right privacy notice or notices. You know, is that the case the Attorney General is going to bring? You know, maybe, but it should give you at least some kind of comfort that, you know, you're not going to be one of the worst actors out there. The plaintiff's bar actually has to show harm. They actually have to show injury, because the My Health, My Data Act is enforced via the Washington Consumer Protection Act, which requires a showing of injury. And if you've got a cookie banner that's clear and giving people an opt-in choice, even if it doesn't meet the full requirement of authorization, a plaintiff's attorney is going to have a really hard time showing true injury there, right? And so when companies are looking at risk-based approaches and things you can do to mitigate your risk, you know, doing something robust like turning the cookie banners to opt-in for Washington State could insulate you from at least the larger risks of this law when it comes to advertising and cookies and trackers.
Awesome. Thank you. So as we kind of round the corner a little bit, we did talk about privacy rights earlier. And so just in the interest of time, Mike, I'm wondering, is there anything you want to highlight here? I
think we've more or less covered this. There's some things here that are net new. The right to delete is troubling because of the lack of exemptions. And if you have a legal obligation to retain data, and this law suggests that you need to delete it in response to a deletion request, you need to make a risk-based decision about which law you're going to violate effectively. And I think most companies are saying, look, if we have a legal obligation to retain data, as long as we, retain it but don't use it, we're going to take that risk. And because it would be hard to show harm simply by retention as necessary to comply with law. The other thing that's on here is there's a pass-through deletion requirement. When you get a deletion requirement, you have an obligation to inform other processors, affiliates, third parties with which that data has been shared. That's similar to what's in the CCPA, but it's somewhat unusual among other privacy laws. So I just wanted to flag that.
Yeah, I do think the geofencing piece is a really important one. Yeah. So, okay, Mike, do you want to talk a little bit about the prohibition on geofencing?
Yeah, this is a prohibition. Opt-in consent doesn't cure this. You just can't do these things that are prohibited under this law. And this is a prohibition on putting a geofence around a location that provides in-person healthcare services. Recall how broad that definition of healthcare services is, where such geofence is used to identify or track consumers seeking healthcare services, collect consumer health data from consumers, or send notifications, messages, or advertisements to consumers related to consumer health data or healthcare services. And this was driven by sort of the stories that we've heard about women seeking reproductive health care, and they're approaching a clinic and they start getting pop-up messages saying, oh, you don't really want to do this, go to this other place, etc. And so that was, again, the motivator behind this, but obviously it's much broader given the depth, the breadth of definitions, including what is a healthcare service. And so again, this is one where I think companies are taking some risk-based approaches. If you are if you work for a pharmacy and you've got an app that has a geo-based functionality that when you enter the store, you might get a coupon or something, is that going to be violative of this prohibition? Well, a pharmacy is providing in-person healthcare services, almost certainly. Are you identifying or tracking consumers seeking healthcare services? Well, you're identifying or tracking consumers entering the store, but maybe they're to buy chewing gum, or something else that wouldn't be the purchase wouldn't be a healthcare service. So you can make some risk-based decisions there. If it's super precise and that they're going to the section that carries over-the-counter drugs or et cetera, then you'd probably triggering that. But merely entering the store, well, maybe not. Sending notifications. If you're showing an ad saying get 20% off whatever you're purchasing here today, is that related to healthcare data or healthcare services? I would argue not. But if it's, hey, get 20% off of vitamins, maybe that is. So again, I think you need to look at how you're using geofencing, how you're using geo-based messages or pop-ups, and make some decisions about that.
Thank you, Mike. And that really just harkens back to our data inventory conversation and having a really accurate picture of what you're doing and collecting and truly how you're using it. So as we start to kind of wrap all of this up, just some practical compliance strategies. And I know we have just a few moments. We've had such an amazing conversation. So, here's a couple different thoughts. And what I'd like to be able to do is, Mike, maybe go to just a few of our questions in our last few moments that we have here together. As a reminder to everyone, we will be sending the recording, and we can send these slides so that you can see more of the details behind them.
Yeah, there's a couple of good questions here. Given the broad definition of bodily function, can this also include anything a consumer would use to manage a bodily function? For example, Kleenex associated with managing a runny nose. Great question. This was actually somewhat addressed in the Attorney General's FAQs, which I characterized as not particularly helpful. They actually use the example of toilet paper, which again is related to a bodily function. And they said the purchase of toilet paper wouldn't normally be considered consumer health data. The adding of the word normally there, I think, was spectacularly unhelpful, because it raises the question of when might the mere purchase of toilet paper count. But they said, the purchase of toilet paper wouldn't count, but an app that tracks digestion would. So, I would say these products that are related to a bodily function, if you're tracking the purchase of tissues or over-the-counter cold remedies, some of that might, some of it might not. But I think if you are drawing inferences based on that, clearly that will be covered. If you are selling cold medicine or advertising cold medicine to everybody who purchased Kleenexes, that inference would be covered. But probably the purchase of Kleenex, that's going to be quite low risk. Exception to consent requirements similar to those in other U.S. privacy laws surrounding sensitive personal information other than California. Well, there are no really exceptions other than that data security exception that I mentioned that are written into this law. It's all around, is it necessary to provide the consumer requested product or service? If the answer is no, it's not necessary, then opt-in consent is required. But I think that, again, as we talked about, you can lean into a little bit of risk and define and interpret necessary as meaning reasonably necessary, which would then allow for a number of data uses that might fall within some of the exceptions that we see in the other laws, sort of those core internal operations uses that are generally allowed. So it's a question of interpretation and whether or not you want to interpret this to be fairly consistent with those other state laws in terms of exceptions. That involves some risk, but if they're pretty benign uses, they're internal, the risk of harm to an individual as a result of those uses is going to be quite low. I think that's a risk that most companies are going to be willing to take.
Thank you, Mike.
Do we have time? We're over time now. Okay.
I think we might not. We are just over 1 o'clock. I know a number of people have left for the day. And so we have so much to talk about. This is just such an amazing topic and 4 billion different questions. So Mike, maybe we can have a part 2. What we can do is we'll, of course, share our slides. There's a lot of really great links that are packed within the presentation. We'll share the recording and we can kind of take a look at any of the questions that we didn't get to address and see if we can provide a short answer back. So we would love to say thank you so much to all of you who joined. Mike, thank you so much for participating today and sharing your incredible wealth of knowledge with everyone here.
My pleasure.
Amazing. Thank you so very much. Have a great day, everyone.
Bye, everyone.